Good afternoon, colleagues, friends, and everyone else joining us today, and thank you for being with us. My name is Yahya Dardashti. I'm a proud member and one of the co-founder of Associations of PICRA. I'll be your host for this exciting webinar today. We have a special guest speaker for you, Mr. Ali Ahmari-Moghaddam. He is a well-known lawyer in Toronto. I'd like to introduce him by saying Mr. Ali Ahmari-Moghaddam obtained his Master of Laws from the University of Toronto Faculty of Law in Public International Law and his Bachelor of Law from the London School of Economics and Political Science. Ali was called to the Ontario Bar in 2013 and established Ahmari Law Firm shortly thereafter. Ali is a proud member of the Ontario Bar Association and currently practices the area of corporate law, family law, in immigration, real estate, wills and estates, and probate. He is also one of the founding members of the Facelaw, an online directory of lawyers, paralegals, and immigration consultants. Since the onset of his career, Ali has published a number of articles dealing with prominent topics pertaining to areas such as real estate law, family law, and wills and estates. Today, Ali joins us to present on the topic of estate planning and the importance of having a will and powers of attorney. Without further ado, Mr. Ahmari, please, we cannot wait to hear from you. Thank you.
Perfect. Thank you so very much. First and most, I would like to thank PICRA for providing me with this opportunity, this platform to have my webinar. And of course, thank you to you, Yahya, for hosting my webinar. That's an honor. Today, I'm going to be talking about estate planning. I'm going to be talking about 10 steps of estate planning. I'm going to be sharing my slides. I believe you can see that, right?
Not yet.
Is it on that moment?
I don't see it right now. Yes. Okay. Yes, you can see it.
Perfect. So to set the agenda today, I'm going to have an introduction, and then I'm going to be talking about the 10 simple steps of estate planning. We're going to have some final thoughts, and then will be an opportunity for question and answer. Now, for the individual who don't have any background on the topic, when we talk about estate planning, we're basically trying to identify who you wanted to give your asset to, when you want to give your asset to. Is it during your life? Is it at your death? Or sometimes after your death? So basically, we want to be talking about how you're going to manage your financials, how you can reduce your taxes, how you can have a contingent plan in the event that you are incapacitated, who is going to be taking care of you when you are incapacitated. So basically here, I have outlined some of the benefits of the estate planning. So we're going to be talking about all this topics as I go on through my slides. So basically, some of the benefits of the estate planning is to distribute assets based on your intention. So you're the one who's going to be deciding how your asset will be distributed and to whom. Provides funds for funeral expenses. A lot of people overlook these steps that have at the time of the death, how they're going to fund for those. And as we all know, those costs, those are very costly. It also places more assets in the hands of your beneficiaries. It can minimize your taxes. It can delineate your personal care preferences, including terminal medical treatments and organ donation intentions. We're going to be talking a little more about that as well. And also talks about the will and your last wishes, and also when you're incapacitated, you want to know what kind of contingent plan you have in place, and of course, who will be taking care of your children. Lastly, estate planning talks about ensuring your business continuity and especially when you're a business owner. So the 10 steps that are quite crucial, and I'm going to be talking about all the steps one by one. I have outlined it here for you, and those was already simple. I'm just going to read it to you quite fast here. So step one, basically consult and retain appropriate professionals. So we want to know who are those professionals that you need to have on your side to assist you with your estate planning. Two, drawing up household balance sheet. Three, determine your life insurance needs. Four, draw up your will. Five, establish powers of attorney for property. Same thing. Step six, power of attorney for personal care. We're going to be talking about how to minimize taxes and how to keep track of accounts and important information. 9, how to communicate your steps, and 10, how to keep track of all those information. So basically, review and update those information regularly. Let's start by step 1. So consult and retain appropriate professionals. Before going further, who do you know that when they have any questions, whether it's to do with wills or taxes or any other questions, and instead of contacting the appropriate professional, the very first platform that they have in mind is Facebook. They go on Facebook and post this question, obscure question, and they're hoping to get sound advice. Similarly, when you have, I don't know, issue and medical questions, you may resort to Google, and you end up with a list of diseases that has nothing to do with your situation. So it basically speaks to the fact that sometimes we are not resorting to the right professionals. So for the purpose of estate planning, the professionals that we need to contact are financial advisor, a lawyer, and a tax professional or an accountant. So when we talk about the financial advisor, we want to have their assistance to help us to estimate the size of the estate and setting up goals and ensure competent management of your assets. I'm going to talk about more about this in my subsequent slides, but quite often people do not have any list of their assets. They have no idea what their debts are or what's their incomes are exactly at the end of the month. So they do not have any contingent plan in place. So that's why it is important to have a financial advisor on our side. 2, we need a lawyer. We need to have a lawyer to help us to draft a will and powers of attorney. I'm going to be talking about powers of attorney for care and property in a few minutes. But we need a lawyer to help us with those, and of course to help us with any state litigations or state disputes. And also a lawyer can also assist us with being a trustee or executor or help executor to go on and do his or her job as is required by law. And third, tax professionals. We need an accountant, a competent accountant on our side to give us sound tax advice about the tax implications and what would be the best way to minimize our taxes. So that's step 1. So we know that we need an advisor, a lawyer, or a tax professional on our side. Second step, we need to draw up a household balance. Quite often when I speak to clients or take the instructions for the purpose of drafting a will, when I ask them, which banks they're dealing with, do they have a mortgage? What's the value? What's the mortgage or balance of the mortgage? They are not quite clear on it. So it's good to have a summary of your financial situation and overall net worth. Quite often people say, well, I don't know what my net worth is. I know that there is a number of formulas, but the simplest way you can just say, what's your assets minus your liability. So the question is, why would we want to have a drop household balance? So basically, you want to see how vulnerable you are when the circumstances shifts for the worse. One thing as pandemic has taught us that we need to have a contingent plan in place. We all been affected by the current situation, not all for the best, but nevertheless, it teaches us that we have to have contingent plan in place. It also teaches what are our tolerances to the risk. How about if one loses his or her job? Do they have enough money saved for those rainy days or not? So we need to draw up a household balance sheet. So that's the step 2 in the sound estate planning. Step 3, understanding life insurance. Now, quite often when I talk about life insurance, people are a little bit hesitant, or they do not want to get involved. They think that it's basically a waste of money. No, I'm not here to sell you life insurance, but from experience, I can say that quite often people use life insurance for different purposes. They can use it, as indicated here, for income replacement. You can pay state expenses, and you also can use your life insurance as an inheritance. Quite often people say, well, how much life insurance do I need? Well, that's not for me to decide. That's why you need a financial advisor. And of course, you have to speak with an insurance broker on that to figure out what are your options, what products are available. I understand that there are different products that may not be applied to all individuals, but nevertheless, it's good to look into it. How much life insurance you need, again, is something that you need to discuss that with your financial advisor for to figure out what is your objectives. So definitely look into the life insurance and the options available to you. So that will be the third steps for the estate planning. Drawing up your will. People quite often ask, well, why would I need a will? Or quite often they say, well, I'm not planning to die. Very simple. Again, one thing that pandemic COVID-19 has taught us is that life is quite precious. You never know what's going to happen to you. It's good to have a will in place. Now I can talk about the importance of the will for the whole day, but nevertheless, I have put 2 points here, which I hope that people take it quite seriously. Through your will, you can appoint who will be your executor, who will be your state trustee. Through your will, you can appoint the guardian of your children. Quite often, people overlook the fact that they have minor children. They overlook the fact that if something happens to them, who will be taking care of their children? Quite often, people think that they have to have certain assets, or they have to have 1 or 2 properties or house, a lot of money in their bank accounts in order for them to have a will, which is not correct. So if you have minor children, I'm here to submit that you must have a will. Now, there are different types of will. Quite often people talk about formal will. A formal will is a will that is drafted by a lawyer, usually signed by 2 witnesses. Or you can have a holographic will. Holographic will is the will that is handwritten, but is definitely not recommended. Going back to my initial point, quite often I see somebody post a comment on Facebook and says, well, I'm thinking about having a will. I'm not sure if that's required or how much it's going to be. And there is always somebody who tries to saves money for you and basically says, well, you don't need a will. Or, once you go on Google and do a search, I'm sure you can come up with some sort of samples. So that individual basically presumes that there is one format of the will that applies to all individuals and to all jurisdictions, which is quite wrong. You need a will to be specific to you. And for that reason, as I indicated earlier, you need to consult with a lawyer. So what goes in the will? In the will, first and most, you say who this will is for. And if you have previous will, we're going to revoke those will. You can appoint the executor. You can have clauses with respect to paying debt, taxes, fees. You can have clauses for common disaster. Sometimes people say, "Well, I want to give everything to my wife in alternative to my children in equal shares." The question is, how about if, God forbid, all of you are deceased in a common disaster? What would happen then? Uh, Also in the will, we're going to be talking with a guardian in the subsequent slides. But again, that's one of the clauses that goes in a will, appointing a guardian, and I think that's quite important. As I indicated earlier, if you have a minor children, you definitely need a will. Uh, there are a whole bunch of clauses called power clauses, and those are the powers that you delegate to executor to do his task as required by law. And attestation. So a formal will, as indicated earlier, has to be witnessed by two. So that those formality has to be followed. Executor, that's one of the clauses as indicated in the will. When we talk about the executor, people just randomly try to select someone without consulting with that individual, assuming that it is basically a simple task. Once I have the opportunity to expand on it a little bit more and tell them about the responsibility of the executor, that's the point that people pause and think for a few seconds and think, "Oh, okay, who am I going to appoint as an executor?" Here are the few points on the responsibility of an executor. Basically, an executor, first and most, they have to be able to, they have to locate the will. They have to make funeral arrangement. They have to find a lawyer to help them with the process. They have to notify the beneficiaries. They have to secure state assets. They have to open a state account. They have to submit will for probate, and that's the process that deals with the court. They have to advertise for estate creditors. They have to convert residual state assets. They have to pay financial obligations or debts. They have to complete final tax returns. They have to distribute inheritance. They have to prepare state accounts, and at the end have to close accounts. Now, this sounds quite complicated, and quite often, in order to complete this process, you may looking at a few months, a year, or even longer, depending on the size of the assets. So when you look at all this, who will have in your mind to be the executor? So it is a very serious decision. Quite often people say, "Well, I don't have any family members," or "We are not in good terms with my family members, with my brothers, sisters, with even children." There's always a way around it. You can appoint a lawyer, a law firm, or trust company to be the executor, and that would remove the burden on the family members. And basically, you can proceed with having a will, because sometimes this is one of the issues. They say, "Well, we don't have any family members in Canada. We don't have anybody we can really trust." So those are the options available to you. Sometimes you want to have a trust company, law firm in alternative. You may have somebody, but you want to have basically as an alternative if the first individual that you have appointed as an executor is not available or basically is deceased. Appointing a guardian. As indicated, this is one of the most important part of your will. You want to appoint a guardian. And the reason you want to have this clause in your will is that you want to ensure that the court knows that you as a parent, who you think would be the best person for the job. There are certain questions that you have to keep in mind in order to uh, choose that guardian. But nevertheless, it is good that to give it a good thought and choose the individual that you trust to be the guardian. Of course, keep in mind, in order to be a guardian, application needs to be made. There's time, usually 90 days, that has to submit to the court in order to be appointed as a guardian. So it's not automatic just because you have somebody in mind or put in your will as a guardian. So that's one of the important section of your will. Step 5, establishing power of attorney for property. Uh, Now, before we proceed, usually people talk about different type of powers of attorney. The power of attorney for property can be a general, can be limited in scope. If you have a continuing power of attorney for property, it remains valid if you become incapacitated. So it's good to have a power of attorney. So the power of attorney for care and power of attorney for property are usually drafted alongside your will, and it's definitely recommended to have it. And the power of attorney basically terminates on that. So definitely consult with your lawyer while you're drafting the will. Talk about drafting a power of attorney for property. And the same thing, we want to discuss about power of attorney for personal care. So basically, power of attorney for personal care provides direction for your health care, nutrition, shelter, clothing, and safety issues. Um, it is quite important to draft it and at the same time discuss the details with your attorney. You're the one who have certain plans for yourself. You want certain things to be done or certain decisions to be made. And those has to be reduced in writing or at least communicated to your attorney. So power of attorney for personal care. Step 7, minimize tax and administration fees. This is a section that uh, quite important when it comes to minimizing taxes. In my first step, I indicated that you need to speak with uh, an accountant and financial advisors to be able to get a sound tax advice. I'm not a tax lawyer, so and I will not be able to provide tax advice. So sometimes when I look at uh, the size of the states, and I see people that don't have a detailed balance sheet and they are not quite sure how to manage it, I definitely recommend to consult with a tax lawyer or an accountant who can go through their states and provide them with detailed plan how to minimize their taxes. One of the when it comes to the property, I pointed down here that it's good to have a joint ownership with the right of survivorship. Those one of the ways that you can minimize taxes. So if you look at the title of the property, you can always own the title of property as a joint tenant or tenant in common. So this will be the joint tenant. Um, so definitely consult with the professional and the financial advisor on this important. Step 8, keep track of accounts and important information. Um, when I meet up with a client, when they will review their assets, and when I basically draft the will and review the will, uh, through that process, I ask them what assets do they own, which banks they have an account with, um, the mortgages, life insurance, RSPs, and so on and so forth. All those information can be changed down the future. So I usually provide them with a specific piece of paper that I'll have list a number of topics. And I told keep track of those information. There's no need for that to give those information back to me. It's for you to keep it beside your will. So those information that is always important to keep it beside your will, copies of birth certificates, passport, bank accounts, insurance policy numbers, and other legal documents that you have. So you can have all those beside your will, and keep track of those accounts. It's quite important. A number of instances I had to act for the client with respect to the probate, and I realized that they do not have any information in place. They don't know, where's the mortgage, what's the balance, uh, which bank accounts is held by the deceased person. They have no idea. So they have to investigate and go through the documents and find those information bit by bit. So it's good to have basically one sheet of paper, reduce everything in writing, and keep it beside your will. Communicate your plan. That's something that quite often, and it can be cultural too. A lot of people lack this step, and they do not communicate their plans with their loved ones. Um, Sometimes when I go through the details of the will and how the assets can be distributed, I can see sometimes people they're not quite sure how to go about it. It had a number of occasions that somebody told me, "Why not I give whatever I own to my eldest son, because he knows exactly what I want, and he's going to give to other family members." And I told him, what you're telling me is that you don't know what you want, and I highly doubt that your son knows what you want. So it's important to think about that. It's important to communicate your estate plan with close family members or friends, and document your estate plan and to reduce any chance of misunderstanding. So if you don't leave any plan in writing, what you say can be subject to interpretation. So it's always good to communicate your plans and talk with the loved ones. Now, review and update regularly. Uh, Sometimes people think that once a will is drafted, that's it, and there's no need to go back to it. And same thing for the balance sheet. So once they have everything in writing, that's it. There's no need to go back to it. But as maybe that you can agree with me, you can always go back to those information. It is always a requirement to go back, especially those financial information. You can always go back and update those. You may bank with CIBC next month. You may decide to close that bank account. You may update your life insurance. You may move from one institution to the next. Your properties, your assets. So all those needs to be updated. So it's always a good idea to revise your plan if your circumstances change. Same thing applies for the will as well. So you can always change your will. You can always update it. And when you think about naming executors and guardians in your will, you need to look at those names and to see if there is any need to update or perhaps name somebody else. And of course, that's for the best interest of your children. I'm here to give you final thoughts. Quite often, and I've heard it over and over, that people say that I wish I knew sooner. I wish somebody would have told me. For you who see this webinar, now you know. To do nothing is not the best option for you or your family. Especially, as I said, if you have minor children, you need to meet those professionals. You need to have your financials in place. You need to have a list of your assets, your vet. You need to have a will and powers of attorney, and definitely need to speak with a tax lawyer or an accountant to discuss your assets and how you can minimize your taxes. So that will be the final task that I'm going to leave you with. And with that in mind, I'm going to conclude what I was going to say. And if there is, if we can deal with the question answers, I think that would be the best time. Yeah, here I don't have your voice. I think your idea is,
Can you hear me now?
yes, I do.
Well, thank you very much, Mr. Ahmari. It was a very informative session. I certainly learned a lot from it. I'm sure some colleagues have questions. Before I start asking you questions, I'd like to mention that PICRA has a networking event coming on September the 23rd, and I would like to invite all our members to come and join us. Please go online, renew your membership, and you also need to RSVP with PICRA to be able to be on that event. We would love to see you there, and all the best. Well, let's go to the questions. While you were speaking, Mr. Ahmari, I had a couple of people asking me some questions to ask you. First one being, when choosing a guardian, what has to be considered?
Right. Great question. As I said, when drafting a will, perhaps as one of the most important part of your will, because that concerns your children. So for the guardian, it's always good to think about who will be the best person that your child trust, who do you trust, and what's that relationship with you or with your children. You can think about how old is that person? Is that person is able to care for your children? Is this person mentally, emotionally, or financially prepared to take care of your children? We can think about if that person has children of his own. Is he capable of taking care of your child? Is he committed to raise your children? So those are the questions that you should have in mind in order to choose the best person. Also, in terms of the financials, you have to think about whether that person is financially secure, or you have to provide financial assistance to that person. So those are some of the questions that you have to keep in mind in order to choose the best person as the guardian.
Mm-hmm. In your presentation, you were mentioning about a will and the importance of it. So what happens if one dies without a will?
Of course.
You know, in the Iranian community, because this is something very new to us, at least in this country,
Mhm.
we come across clients who don't even believe on doing one. So please explain the importance of this for everybody.
Absolutely. I'm glad that you mentioned about the our community, Iranian community. Brings me to a memory that a couple years back, I was at the Persian Bazaar. I had a table down there, and on my desk I had a number of articles. One of them deal with importance of having a will. So this lady who came and basically was looking at the articles and ended up picking one of the articles that deals with the will. And it was quite interesting that this lady had a child. It's very, obviously probably just a couple of months old, and also had an old boy that was just running around. And when she saw this article, she was rather not pleased seeing such an article, saying that that in such a great occasion, Persian New Year, why are you talking about with will? That no one's want to talk about dying here. And I was quite mesmerized, and I said, God forbid if something happened to you, who's going to be taking care of your children here? Do you have any family members? No, she didn't have any family members. She had no idea who would be taking care of her child. So those are very important. So back to your question, if we don't have a will and you die, basically, you're saying that you have not left any instructions for your assets, or basically they said somebody died intestate. So in that sort of scenario, one of your close relatives or family, they have to apply to become your personal representative. They have to apply to the court and bring an application to Superior Court and to pay state administration taxes. in order to get a certificate of appointment of estate trustee without a will. Now, this is a very lengthy process as well. And with that certificate, they are able to manage and distribute your estate. And just like having a will, they have to apply and pay the state information return. But if we don't have a will, as I said, going back, you leave it to the court or somebody else to decide for you, for your estate, for your assets, for your children, and so on and so forth. Is this something that you want? Probably not.
Mhm. Mr. Ahmari, I heard yesterday that in the States, if somebody dies without a will, uh, the government will take 50% of the equity that that person has. Is this the same in Canada as well?
Well, keep in mind that the laws are not the same in all jurisdictions. Now, when we're talking about the state, United States, which state are we talking about? Laws are different. Even the same thing here in Canada. The laws can be different from province to province. So you have to consult with a lawyer to see what are the laws in that jurisdiction that you're talking about. So the law basically says if you don't have a will, it doesn't mean that the government can take everything just because you don't have a will. But the law has created a list of who can apply, who will be the beneficiary of your will. But if you don't find any of those beneficiaries, perhaps government can put their hands on, but it is not automatic. Just because you died without a will means that everything will go to government. So again, depending on where you're located, you have to discuss with the lawyer to see what are the laws of that jurisdiction.
Thank you. And I have another question here for you. How does marriage or divorce affect the will? And could it be changed after a person actually makes his will?
Sure. So the effect of marriage or divorce. So that definitely both of them can affect your will. In terms of marriage, some argue that it will automatically revoke the will. So when you get married, it is definitely recommended to have a new will, unless it is made in contemplation of marriage. So basically, your will should have statements that make reference to your upcoming marriage and the name of the spouse. And if that's not the case, some may argue that you have died intestate. So for that reason, if you getting married, or if you had a will and then you got married, it's definitely recommended that you update your will. In terms of divorce, if you get divorced, it doesn't mean that your will is canceled. So basically, any provisions in your will that refers to your spouse, basically those clauses are revoked. Now, you may have your spouse as your executor, or a trustee or guardian, and obviously you may have clauses in your will that deals with giving a gift or a certain property to somebody. So those will not go to the spouse, but to someone else, and that depends on the structure of your will. And in order to avoid any confusion, again, it is definitely recommended to update the will. As far as changing a will, you can always change your will. There's no limitation. I think that was your last question, right?
Okay, that's right.
When you draft a will, there's no limitation. There's no restriction. You can always change your will. And when you draft a will and you change, let's say, a paragraph or a certain portion of it, they call it a codicil. So to the codicil, you may add something, you may delete something, and the procedure of drafting that codicil is just like drafting a will as well. So certain formality has to be followed, has to be witnessed, and we have to be clear exactly which paragraph we are deleting, which paragraph we are inserting, and as I said, two witnesses has to sign it as well. Now, I had occasions that people make too many codicils, too many changes to their will. As I said, there's no limit, but nevertheless, if you are making a lot of changes to your will, perhaps it is better to draft a new will. So that's just my recommendation.
Thank you. One of my colleague, Mr. Bellucci, is asking, what is probation? How long does it take? And how much is the cost?
So the probate basically is the process that you submit the last will to the court, and you get that certificate. Now, if there's no will, you submit, and in order to get a certificate of appointment of estate trustee without a will. There is no specific date for it, depending on the court. I had occasions that I have to bring a motion for urgent matter to get the probate done. But nevertheless, there is no specific date attached to it, how long it will take. And for the probate, we have to look at the value of the assets. There is a formula as of January 1st, 2020. There's no taxes for the value of estate of $50,000 or less. Anything above that, $15 for every $1,000 will apply. There's a number of websites that you can go and you can insert the value of the estate, and that will tell you how much is the state administration tax that has to be paid. So usually a lawyer will assist you what assets are included, what assets are excluded, and based on that, they will determine the value of the state, and based on that, they determine how much have to be paid. Is less than 50,000 or more than 50,000?
Sure, thank you. I have another question from Simin. She's asking, how long does it take to appoint an executor when there is no will?
So the first question is, who will be the person who is allowed by law or qualified to appoint to become the executor? The first instance will be the spouse, then children, obviously, who can apply, and then, as I said, the formality of just like having a will. You have to determine what's the value of the state, and you definitely need the assistance of a lawyer to submit the necessary document to the court. The process can be lengthier, be longer, because quite often when there is no will, we don't have the list of all the assets. In one of the slides, I spoke about the how you draw up a list of your assets. When there's no will, most likely they don't have such information in place. As I said, in a number of occasions, I had that even a spouse of somebody, I have no idea which banks my husband, banking with. I have no idea, or he has lost his wallet and I have no idea. So basically, you have to go through all the documents, or wait for statements from the banks to come in to see exactly which bank that individual has banking with. Now, both for corporate accounts and personal accounts. So it can be longer, the process, but again, there's no specific dates. It's better to work with the lawyer to figure out what documents needs to be filed with the court.
I see. Thank you very much. Another question, I think we still have time. Another question from Sarah. She's asking, should we change the will if we get new property?
Not necessarily. Not necessarily. I've seen people putting the address of the property. Sometimes it is better not to put the address unless you are actually given that property as a gift. But if you have a property and then you sell that property and buy a new property, not necessarily, you don't necessarily have to update that will just because you bought a new property. So, but if you have a property that you have listed and you're saying that that specific property goes to somebody, and that now that property has been sold, probably you have to update your will.
Okay, thank you. I have another question from Sherwin. She's asking, do we have to make a new will if I move between territories, or if my martial status changed due to new move to that move?
Uh, it is definitely recommended. So if you move into new territory, or for your you get married, and or perhaps going through divorce, definitely, as I said, it is best to. I think that was your second question, that we talked about marriage and divorce. So definitely it is recommended to update your will. People may hold assets in different territories. You may have, certain assets, let's say, in Nova Scotia, now to have some in Ontario. So definitely you need to talk to a lawyer in those territories as well, to make sure that your will is enforceable in that territory as well.
Thank you. And I have a question of my own. Um, as you know, as real estate agents and brokers, we come across a lot of investors who jointly buy investment here in Canada. For example, two friends or two brothers, or brother-in-law and a friend, and all kind of things that they buy properties. At a time they buy, one doesn't have a spouse, then 2 years later he has a spouse. I had a case a long time ago when one person died, and it made a big problem for everyone else. So, what do you recommend when people come to us and they want to buy properties jointly, who are not, it's not a married status, for example, two brothers or two friends?
So, in order to answer your question, we have to look at different laws. That is not just talking about having a will, but also there is a real estate question, also a tax question as well. Um, and also, I mentioned earlier, when you look at the title of the property, you hold the property as a joint tenant or tenant in common, right? So if you have a joint tenant, all those individuals equally owns the whole property. So if one of them is deceased, the next person is the owner of the property. So if that's not the case, perhaps they have to consult with the lawyer to have the title of the property as a tenant in common, in which each of them will own certain percentile ownership of that property. So that's one way to look at it. The drafting will, yes, it can help you definitely, but if they are buying a property as an investment, they may want to enter in some sort of agreement, either a trust agreement or a joint venture agreement. So something has to be reduced in writing. It is, again, sort of a cultural thing that people trust each other, and it's okay, let's buy a property and let's just put your name on it, either for land transfer tax purposes, or for the convenience, because somebody's here in Canada and perhaps is a Canadian resident, and have that individual as the owner. Now, exactly as you mentioned, how about if that individual is deceased? Now, who's the beneficiary? Is it the partner, or is it the spouse? So if you don't have a will, most likely, at least the idea is that your spouse and your children are the beneficiaries. So in order to avoid that, one has to perhaps retain a lawyer and brings the case before the court to secure their own interest. So there's a number of options available. As I said, they're drafting some sort of contract or trust agreement, or a joint venture agreement, or look at the title of the property, how they go about having that title registered when they purchase the property.
Thank you very, very much, Mr. Ahmari. And I'm sure my colleagues can contact you at your office or at your website. I can see here ahmarilawfirm.ca, and I'm sure you can help them in any ways you can. Once again, I would like to thank everybody who has assisted me doing this webinar today, Canada Create, all my colleagues at PICRA. And once again, I would like to ask everybody to join us on September 23rd for our celebration and networking event. Please go on site, on website, and register yourself. And I'm sure you have to extend your membership with PICRA as well. Once again, thank you very much, Mr. Ahmari, and hope to see you again.
Absolutely. Thank you again. I appreciate the opportunity. Thanks for all those individuals who posed some questions. As Yahya indicated, if you have any questions, feel free to contact me. You can drop me an email. I'm sure you can find my phone number on the directory as well. You can. I'm just a phone call away. I understand the state issues are complex. It's not as easy as was sort of outlined. But again, here, I'm not here to give any legal advice. The idea is to make you think about those important issues. But if you have any questions, definitely feel free to contact me. And thank you again. I appreciate it. You've been absolutely amazing.
Thank you. Thank you very much.
Thank you.